Good evening. Thank you for joining us. You are listening to the Veterans Voice. This is Amanda Manier. I am your host. I am the managing attorney at the Veterans Law Group and a veteran advocate. We have been working in this industry for over 25 years, and one of the joys of my job is to host this show called the Veterans Voice every Tuesday evening, talking about how we can help you as veterans or family members of veterans navigate the process of the VA system when it comes to seeking disability compensation. So for those of you who are new to listening to this show or maybe unfamiliar a little bit with VA benefits or veteran benefits that we as the general public promise to support veterans after they leave the military and continue on in their civilian life, part of their contract is that if they have any sort of injury, physical, mental, that is incurred, meaning it happens it starts while they are serving our country, or a previous injury that is aggravated by their service, then we agree as the general public, as American citizens, to make sure that those injuries are taken care of for as long as those disabilities exist. So in some cases, that's going to be for the rest of their life, and in some cases, it may be temporary. But with a lot of injuries, they don't just disappear. And with a lot of orthopedic type of things and sometimes mental health, they tend to get worse over time. Just kind of depends upon each individual veteran. So what I get to do for a living as the managing attorney of the Veterans Law Group is to help veterans and their families walk through the system, dealing with a very large bureaucracy with a lot of red tape. It is a government entity, so by nature of that, we are going to see those things. I look at my job as helping the veteran to kind of walk alongside of them and put all the ducks in a row to help the VA to make it easy for the VA to grant their case. So what we like to do on this show is to, if we're live, and we are live this evening, is to take your calls and talk about your questions related to this process, specific questions related to claims or general questions. Happy to take your calls here. Our number here is 800-222-5222. If you give us a call and talk with the screeners about what you're interested in talking about, and we'll take calls. I generally also have a number of things that I'd like to talk about or to kind of put out there, but I will always put those aside to take calls as priority. Generally, we're going to look at things like what's happening in the news, some things that I think that you all might want to hear about. And then some subject matter, dig into a little bit of, what you can learn while listening to this show or this podcast, if you're listening on the podcast, of how you can help support your claim. As attorneys, we work only in the appeals department, which that means that a veteran has to have received a decision already for their VA disability compensation. And if they, just want to have it reviewed to make sure that they're getting the benefits that they're supposed to be getting, we are happy to do that. We do that free for a consultation on our website, veteranslaw.com. That's veterans with an S, law.com. There's a little button there that says, see if we can help you. It'll ask you a series of questions, ask you to submit your rating decision, and we'll review it and kind of help you see whether or not it's worth appealing or whether or not we can take on your case. Because we do everything only on contingency, we are very selective of the cases that we're going to take. We want to make sure that we can believe in your case and make sure we can get you a positive decision. Doesn't mean we don't take hard cases. We take them all the time. Those are the ones that often become the most rewarding, are the hard cases that we might have to fight for a number of years for, but we're not going to give up until we get you what you need. So again, we're here at 800-222-5222. Sometimes also on this show, we'll take have a guest talking about organizations that are helping veterans in different ways. We've got some upcoming that are scheduled to air in the future of organizations that are doing, they do schooling, they do getaways, they do camps. One of the ones that I was doing a little pre-screening with the other day, they really support veterans with PTSD and get them away to a private island for, I believe it's 12 days, with counselors, with other that are also veterans, just kind of helping getting they do yoga and they do just getting a different kind of insight in life and how you can be surrounded by people who understand what you're going through and still kind of see the light on the other side. Really excited about being able to interview that organization. But again, this evening we're going to get really practical. One of the things that's on the topic here is when I get a rating decision, how do I decide whether or not it's even worth appealing? How do we make those decisions? So we will talk a little bit about that, given that if we have the time to get to that. Again, taking your calls live this evening, 800-222-5222. If you are a veteran or somebody who was looking to help a veteran with this process, we would be happy to help you with that. Okay, so one of the couple of things that I wanted to discuss this evening is some of the things that are happening in the news lately. One of the hot topics with the Supreme Court being back in session, there was a recent discussion at the court. They took oral arguments on Tuesday. Essentially what that means is that if a case gets up to the Supreme Court that is VA related, veteran related, it means that a veteran has filed a claim at the VA. The VA has denied it, and they appealed it up to the board, and they appealed it up to the Court of Appeals of the Veterans Claims and the Federal Circuit. And ultimately, the last stop is the Supreme Court. Well, I'll call it the second to last stop, and I will explain that here in a minute. But the last stop is the Supreme Court of the United States. So as a veteran who's filing a claim with the VA, you do have the ability to appeal your case all the way up to the Supreme Court. When it gets outside of the board and you get into the federal court system where you definitely need an attorney that's helping you navigate that, it gets a little bit different because it comes down to you don't have the ability to submit any new evidence. You're just making argument that the VA did something that either was contrary to what the law states or that the law that it is written is being interpreted in a way that it should not be interpreted. So there's been a lot of hubbub about this case that's at the Supreme Court. And what I hear a lot about is that, oh my gosh, it's going to change everything because if they grant this or overturn this, it's going to allow veterans to get an effective date for their claim all the way back to the time that they left the service, regardless of when they filed a claim. So I'm going to break that down a little bit for you. Of when you file a claim with the VA, the important things to look for is you need to get it service connected, which means the VA is acknowledging that your disability or whatever injury you had is related to your service. Then they're going to give you a percentage based upon your symptoms or how severe that condition is. And then they're going to give you an effective date. And that effective date means the date that you will start being paid a monthly compensation for that disability. Now, generally, when you file a claim, it's going to take a number of months and sometimes even years if you have to go through the appeals process. And so that effective date is what your back pay comes to. So easy example is for a tinnitus claim. Many people have that. It's that buzzing in the ears. So if you file that claim, say this year you filed it in July, and come in October, say today you received a decision and it granted you service connection at 10% effective July, then you will get a 10% payment, which is around $150 back to July. So you'll get a little lump sum of back pay. And then from this month going forward, so starting in November, you'd be getting that about $150 every month for the rest of your life or as long as that condition is still active in your life. So effective dates become really important because if you end up going on appeal getting a higher percentage or you're initially denied a service connection, that back pay, that lump sum is going to go back to that date. So right now, the law states that the effective date is the date that you file your claim for disability, or if you file your claim for disability within the first year of leaving your service, the effective date will be the date after you left the service. So right now, if you left the service in July, let's use those same dates in July, and you file a claim here in October, if they grant you service connection as a percentage, they'll pay you all the way back to July, even though you filed in October. However, if you wait past that year, then the effective date becomes the date that you filed the claim, regardless of when the injury occurred or when your diagnosis is or any of those things. It only will go back to the date you filed the claim. So people ask me all the time, are we currently working with, say, Vietnam veterans, Korea veterans, World War II veterans? Yes, we do work with those veterans on a regular basis because if they waited to file a claim. We see this all the time with Vietnam veterans waited to file a claim for PTSD till many years later, maybe because they didn't know about PTSD, or early on, even the VA wasn't really understanding of PTSD. So years go by, your effective date of when you start getting paid is only going to be the date in which you filed that claim. So this Supreme Court decision, or the Supreme Court argument or case that's being argued at the Supreme Court, is a Navy veteran who is saying that he was past that first year, but because his service-connected disability precluded him from understanding that he was eligible for benefits, that there was extenuating circumstances. So essentially what he's arguing, and I haven't gotten into the details, but I'm going to try to make it very simple. If you have a mental health condition that is that could be something that is arguably saying, well, even though, first of all, maybe I was never told, or I was told, but I didn't understand, it didn't put it all together. So once somebody actually helped me and I was able to file for benefits, it may have been 15 years later, and this person is arguing there were extenuating circumstances, and therefore there should be a waiver or an exception to my circumstances or my condition or my effective date, and it should go all the way back to service. So it's interesting to see there's, again, a lot of discussion of like, oh, it's going to change everything, that everybody will be able to get an effective date back to date of service. Not true. I would just want to be very bluntly honest. I will always be honest with you on this show. It's not going to apply, even if they do grant in favor of this veteran, it's not going to apply to every veteran. They're looking at very specifically that there were extenuating circumstances that this veteran did not apply for their benefits within the 1 year period of time. So if you have a question about that, or would like to talk more about that, or even your claim in general, I just wanted to give a little bit of clarification of what's currently going on. It's very interesting. It will change some things. It'll add a aspect or something to consider, especially if you're on appeal and you're working with an attorney. It'll add an evaluation that we will make to every claim as to whether or not we would seek earlier effective dates based upon this. But again, oral argument has just been made. The decision has to come down from the court and then get passed back down. So this evening, this is Amanda Manier with the Veterans Voice. Thank you for joining us. We are live here this evening. Welcome to take your calls regarding your VA disability claim, or if you're a family member or a friend of a veteran who is interested in helping a veteran with their claim, or just has some questions. There's a lot that's going on, obviously, in the world and in the news. Veterans are one of those that all of us, no matter what our political affiliation or who we are, I think that it's pretty universal that we want to help veterans and make sure that they're taken care of. The VA was set up as an entire organization to help veterans, not only medically, but also through compensation for disability claims. That's the area in which we work in. Before we went to the break, we were talking a little bit about just some of the things in the news with regards to the Supreme arguments that were made at the Supreme Court last week about effective dates of claims, which if the Supreme Court ends up granting that will be a big shift. Won't necessarily apply to everybody. So I wanted to provide some of that clarification. Incidentally, sometimes we get on these shows kind of into the nitty-gritty of claims. And if you want to listen to any of the previous shows that we have recorded, you can always go to the KABC 790 website and find us there, or on our website, veteranslaw.com. Click on podcast. You'll find all of our episodes there, and then we're out on all of the podcast broadcasting. So we tend to answer questions, but also address particular things and sometimes get very specific. With regards to specific questions, and let me give you your number here is 800-222-5222 if you'd like to give us a call and talk about your claim or have some questions. But specifically talking about FAQs, one of my positions or responsibilities at the Veterans Law Group is to help review potential clients. So when you contact our office or go through our website, you'll go through about a 30, sometimes 45-minute or long initial call consultation with one of our team members here. They're amazing, and they're very supportive and very knowledgeable. So even if you or if you're a little nervous about that, I would highly recommend you do it. If you just have some questions and maybe you don't want to talk on the air with us, you're welcome to contact. Our website is veteranslaw.com with an S, and our number there is 800-811-0523. But if you'd like to talk on air about it and talk about what's going on with your case and get some advice directly from me, feel free to give us a call this evening. We're here till 8 o'clock every Tuesday from 7 to 8 o'clock, 800-222-5222. As part of my job, as I was mentioning, is to help kind of do screening calls. So I get a lot of, or screening of clients. And so I get a lot of information. I see a lot what's going on of questions that are coming up and some of the things that the VA is doing. If you listen to the show, you probably have heard me say this a dozen times, but I will say it again, is that, my job is to put all the ducks in a row, make it super easy for the VA to grant your case. And so when I look at a claim, I'm looking at, okay, it's not just about the letter of the law. It's how the VA is currently applying that law, which does change, and just policies and trends and tendencies based upon where, to be honest with you, where the media is paying attention, where the resources are being put. And so when I look at it, it's like, okay, this is the best route to go strategically for this client to get them their benefits to the fastest way I can get them. And some, there's always options with the VA of how do you appeal it one way or how do you appeal it another. But what things that I want to start addressing a little bit more is some of the FAQs, kind of frequently asked questions, things that come up regularly when not only with our clients that contact our office or that are working through the process, but also with the potential clients. So one of the big things that gets asked to us a lot is, or I guess not necessarily asked to us, but it's something that we experience a lot, is frustration on behalf of a veteran that they call the VA, the 1-800 number with the VA, and they get a answer, or somebody, whoever calls they talk to, gives them an answer that says that their case is closed, or that they're being reduced, or that, stuff that doesn't necessarily make sense. And we get calls of a veteran who are frustrated and upset and like, the VA told me X, Y, and Z. The VA told me I was being reduced. I just had this call today. The VA told me I was being reduced. And I was like, wait, the VA can't just reduce your compensate. They can't just arbitrarily say you're getting paid at an 80% rating and next month you'll be at a 70% rating. They can't do that. There's an entire due process requirement that the VA is required to do to process and to give you an opportunity to object to the reduction. And so for reduction, as an example, if periodically the VA, usually between 3 and 5 years, the VA, after you've been granted a disability percentage, they'll call you in and have you reevaluated to see if your condition has gotten worse or better. So say a back claim that you're currently being rated at a 40% for your lower back, and you're in that 3 to 5 year, and you get called in for a evaluation. And after that evaluation, they say, oh, it looks like your condition has improved. So what they are required to do is to send you a letter and say, based upon your recent examination, it looks like your condition has probably improved. So we are going to propose to reduce your back condition from a 40 to 20%. However, in that same letter, you've got a couple of things. One, you've got 30 days to request a hearing with regards to that reduction, 60 days to submit any evidence that counters that reduction. So if you immediately request a hearing, that's going to stop any reduction whatsoever until you have that hearing and a new decision is decided. And if you submit evidence within 60 days that supports, maybe you had some private treatment, or maybe that examination you went to, you had a really negative experience with, that, the doctor didn't really measure you properly or pushed you past your pain point when they were measuring your forward flexation, or, they didn't allow your wife, there could all be kinds of reasons that there could be a bad examinations or reason why you shouldn't be reduced. So they're never just going to, arbitrarily reduce your percentage. There is an entire, what we call in the legal world, due process requirement that they have to fulfill in order to make that reduction. So this veteran in particular had that proposed reduction. We had the hearing about the proposed reduction, and then he was told by the VA like 2 days later, that he was being reduced. And I'm looking at his VA file because, of course, he called me really upset. And I'm like, there's no way in 2 days they issued a decision about his reduction. I just know that intuitively from working in this industry for a while. So I pulled up his VA file that I have electronic access to, and there was no decision about his reduction. There was just the proposed reduction. So he had gotten misinformation from the VA. So what I would like to just remind everybody, and again, we're taking your calls live this evening. If you'd like to contact us, 800-222-5222. When we're talking about proposed reductions, we're talking about calling the VA. This is an example with a proposed reduction. The VA, if you call that 1-800 number, and this is why you'll hear me say over and over and over again, don't walk this alone. Always work with a representative. If you're in the initial claims process, work with a veteran service officer. You can find them at DAV, VFW, your local county office, your local state office. Everybody in the entire country should have access to a VSO that's relatively close to them. And these days, we even work remotely. So that initial claims process, don't do it alone, because you'll help to understand, or you'll have somebody who's has helped you understand, or can help you understand not only the process, but also counteract some of this anxiety that goes on with the claims process. Your representative, when they're filing your claim and you're waiting for a decision, and even after they get a decision, they have access electronically to your file, or they should, if they have followed the process and been accredited. So I pulled up, just the example that I was giving you, I pulled up the veterans claims file, and I saw nothing in there about a proposed reduction. So often what happens when you call that 1-800 number, you have to remember that you're calling a call center. And a call center, whether they're local, overseas, whatever, most of them are local here, they're going to pull up, they have they don't know anything about your file, and they don't know anything about processing claims. All they know is when somebody calls, I'm going to take their call, and I'm going to look up, see what's going on in their VA file, and I'm going to respond to it. So this person talked to somebody who saw a proposed reduction, and their response is, well, the VA is reducing you. And so obviously the veteran got really upset about that. And really it was just a proposed reduction. They hadn't actually done anything yet. So I can tell you that's a very just kind of simple, succinct story of what happened when you call that 1-800 number. When you're looking for information, this is why, again, it's important to have a representative. When you're looking for information about what's happening with your claim, if you have a representative, and you should, always call your representative and ask them what's happening with your claim. Because so often, if you call that 1-800 number, you're going to get somebody who is reading off a screen, who doesn't know what's going on in your claim, and can give you misinformation that just skyrockets the anxiety of what's happening. That's one example. I could give you many of situations in which that 1-800 number has not been helpful. Now, before we go to a break, I will tell you a couple situations in which that 1-800 number is helpful. If you are looking for, you had a rating decision, and maybe you threw it in the trash, crumpled it up, shredded it, whatever, because it made you mad, you can always contact them and ask them to fax or email you. Generally, it's fax a decision to you. They can have access to it and do that. So look at it more from a administrative information. You can call them if you need to reschedule an exam or anything like that, but not about what is happening in your case. I just caution you with that. I am a veteran advocate and the managing attorney at the Veterans Law Group, and we have been working with veterans for over 25 years, veterans and their families, pursue their VA disability benefits and kind of navigate the process. So one of the joys of my job is I get to host the show to help you all and help educate you all on how you can support your case. When we're working with the VA, it's a incredibly bureaucratic process. It is the U.S. government we were talking about. And so it's not that there isn't people that are willing to help. It's just there's possibility red tape. There are also people that I would describe as there's laziness that happens, there's frustration, there's bureaucracy, there's all kinds of things. I think people to a certain extent can often get a little disgruntled at work at the VA. And so my job and what I look at is with our clients is to how can I make it easy for the VA to grant a case? So I spend a lot of time reviewing decisions and evaluating kind of what's the best strategic way to approach a decision and an appeals process. We work only in appeals, which means that if a veteran has to have an initial decision. We also talk a lot about this show about, things related to how do you file a claim and what is the best way to file it. But then after you get a decision, what is it that you can do? What are your options at that point to, one, make sure that you're getting what you're entitled to, or two, if you've been denied, how do you counteract that denial? So when we work on the show every Tuesday evening from 7 to 8 o'clock, we're here. And this evening we are taking our calls live if you would like to join us at 800-222-5222 if you have a question about your claim or a veteran in your family you're trying to figure out kind of how to help. I'd be happy to answer those questions as well. That is how I personally got involved in this area of law and working in this industry, was helping a friend of mine through this process. But if you have that question, you can call us. 800-222-5222 is our number here. Otherwise, I generally have a couple of topics and things that have come up over the last week or number of weeks that we've seen in our office of things that veterans are experiencing in different aspects. Before we went to the break, we were talking about some frustration of calling the VA and calling that 1-800-827-1000, I believe it is. I forget the number always because I don't call it ever. As a representative, I have access to our client's VA file directly, so I can see what's going on. So if you have a representative, and you should, everyone should, contact them. You'll get more information. But you can always get things like a copy of your claims file or a copy of the CNP exam report when you went to the VA and got examined for a condition that you filed. You can get that from them. So stuff like that is great to call them, and they're usually generally very helpful and will fax you a decision and that kind of thing. But getting information on like the status of your claim is not really helpful there. The other thing I'll say, and something that comes up a lot, is related to congressional inquiries. So that essentially means everybody, obviously, in our entire country, you have a congressman that is assigned to your particular district. You also have senators. This is all federal law, so you're looking at it from a federal representative. What can I do? Can I contact my senator? Can I contact my congressman? And what can they do for me? I get that question a lot. And what does that really do? So there's a couple things I'll tell you. And part of it is, I jokingly always say, if you ask an attorney a question, the most common answer you'll get is it depends. But it's true. It really does depend. And in this situation, what it depends on is who your congressman is and who your senator is and who they have in their office that is helping with these types of inquiries. So many congressmen and veterans, congressmen and senators, if you go to their website, they might have a section on their website where it's help with a federal agency. That's a very general thing. It might have a drop down that includes VA or Department of Veteran Affairs. The ones that are very much more pro-veteran are probably going to very specifically call out veterans. Are you a veteran and you need help? Now, you generally have to work with whoever your congressman is and your senator is, because they generally will ask you when you fill out a form to request some assistance, what your zip code is, that kind of thing, because what they're wanting to do is help their constituents. And if you're not one of their constituents, you live in a different state or a different district, they'll want you, or you should be going to that particular congressman. However, I will say that if your congressman or your senator is not helpful to you, it doesn't mean that another congressman or senator that maybe is on the Veteran Affairs Committee or is a veteran themselves that will not help you. It just might be a little bit more of a maze to get some help. So I would say always start with your direct senator or congressman. So this is an example in which maybe you filed a claim, you've been denied service connection, or you've been underrated, you filed an appeal up to the board, and you've been waiting a year and a half. And so it's like, okay, what is going on with my claim? I can't get any information out of the VA. It's frustrating. And you want to contact your representative, which you 100% have the right to do. And when people ask me, do I encourage or do I not? I generally do encourage it. For one, I think that it's important for our representatives to understand what the veterans are actually dealing with over and over and over again if that's what's needed. From the VA perspective, what happens within the VA is you contact your senator. The senator submits, usually somebody on their staff who is assigned to handle those kind of things, will submit a congressional inquiry to the VA on your behalf saying, hey, I need to know what's going on in this veteran's case. Sometimes they will ask you to file a release of third-party information. Sometimes they will ask you to file a power of attorney because the VA can only give the congressman or the senator information on your case if you give them permission to do that. So there's generally a form that is required to do that. My caution in that is if you have a representative like a law office like ours or a VSO that you don't want to lose power of attorney, you don't want to lose their ability to act on your behalf and to talk to the VA, I would hesitate to sign a power of attorney with the congressman or senator's office. You can sign something that's a third-party information where you're granting the VA the ability to disclose information to the senator's office, but it's not giving them power of attorney that takes away from somebody else. So that's kind of the first piece of the puzzle. So then the congressman will put a congressional inquiry on your VA file. And the VA has congressional liaisons in every regional office across the country, and they are responsible. Part of the responsibility is to look at your case and give a report back to that congressional inquiry about what's happening in your case. So it may be that, well, the veteran filed an appeal in January of 2022, and it's currently being looked at, but we have a backlog, So sometimes, and I would say generally most of the time, the response that comes back to the congressman or the senator isn't really helpful. It's really just kind of information like, we received this appeal or we received this claim, we're working on it, we're really backlogged, this is how long it's generally taking, their number, 20,000 to get a hearing at the BVA. They'll give you some information. So when you come to a congressional inquiry, it doesn't magically make stuff happen. However, I will tell you that within the VA system, your case gets flagged, what they call a flash, with a congressional inquiry, which means that when somebody is looking at that case, they know that a congressman or a senator has inquired about this case. And it's the same kind of thing, like I've said in the past before, of when you're working with a private attorney, there'll be a flash on there that says attorney case, and it might be attorney's fees. And they will not say this publicly, but they have said it to me many times privately, that those cases don't get priority attention, but they do get higher attention in the sense that they we better get this one right. We better look at this one further. We better spend a little more time on it. So a congressional inquiry doesn't, again, magically kind of make something happen faster, just like working with an attorney doesn't magically make something happen, but it does create a higher level of attention by the VA once your file is finally looked at. One of the biggest questions that I get when it's like, how does and why does a case take so long before the VA? They have everything that they need. They have everything that they need. I hear that over and over again. Yes, everything is sitting there in a file waiting to be looked at. And once somebody opens and looks at that file, whether it's electronically, now everything is electronic, but electronically, then they'll see, oh, everything's here. Now we can grant that case, or now we can do what we need to do. But until somebody opens that case, that's what becomes the frustration of the length of time that it takes. So basically down to the summary of what I've just talked about is congressional inquiries. Yes, contact your senators and congressmen. Just keep your expectations in check with what is actually going to happen with that. But I've never seen ever it have a negative effect. Just remember, contact your local senators and congressmen that represent you as a constituent. Amanda Manier, you are listening to the Veterans Voice here on 790 KABC. I'm a veteran advocate and managing attorney at the Veterans Law Group, and we have been discussing this evening issues that are related to, or every Tuesday evening here between 7 and 8 o'clock, we are talking about issues that are related to kind of navigating the process of the VA disability claims system, bureaucracy, red tape, whatever we want to call it. And I generally kind of like to break it up a little bit of some of the FAQs that we've been getting over the last couple of weeks, or some of the things that we've kind of run into. And this evening, kind of before we went to the break, I was talking a little bit about, when do you know whether or not you should contact your congressman or your senator to get some movement on that case? I would generally say that it's not necessarily a bad idea unless you contact them like the day after you file your claim. There may not be much that can be done on that. But the other thing that's been coming up a lot with veterans who've been contacting our office is that just the question or the idea of, okay, I have received a decision. How do I know if it's like the right decision, or even if I should file a claim or, file an appeal? One of the things that I'll say, and I'm just going to try to talk about this with our limited time, let's a little bit generally, and maybe give you some examples. I am planning to do more of a substantive show, a longer show about looking at specific issues and how you know what you should do with those. As I've always talked about, is that you shouldn't be doing this on your own, but I generally know, and when I say not on your own, I mean, if you're filing a claim, there's a law out there that says that nobody can charge a veteran for filing an initial claim. And that means that you either, one, do it on your own, or you work with nonprofit veteran service organizations that do this for free for veterans. That includes, organizations like VFW, DAV, San Diego County, VA, Los Angeles County Veterans Associations, or veterans departments who have VSOs who know how to file claims, who can help you with the process. And they can help you, not only identify some issues that should be filed, maybe that you're not necessarily thinking of, some secondary conditions or things that might come up in the future, but also they know the system. And then as a representative, they have access to your electronic VA file. They can see what's happening with your case. You may not be notified, or you won't be notified by the VA that they have made some inquiries to the National Archives to see if the stressor that happened to your unit or your ship, if there's any sort of deck logs about it. You may not know that process is happening, but a veteran service officer who has access to your VA file would be able to look that up and see, hey, it may feel like 3, 5, 6 months has happened and nothing's happened in your case, but I can see that the VA is doing some what they call development on your case. They're asking questions and they're requesting stuff from archives and things like that. So one of the many reasons that I say not to do it alone. Once you get your decision, that's when you have the option to work with an organization like ours, the Veterans Law Group, with a law firm, having an attorney represent you on your claim. At that point, you can do that. Most attorneys work on a contingency basis, including our own. But just in taking a little bit, just from an educational perspective, I always look at myself as I'm not a lecturer or presenter, although on these shows I feel like I talk a lot and somewhat lose my voice sometimes. But I'm looking at, how can I educate? I'm a teacher. How can I educate and help you all to make some kind of decisions onto whether or not you should pursue something? Once upon a time, early on in my legal career, I worked for an insurance company, and I worked in a regulatory compliance department where we wrote rules related to appeals. And I was so amazed at how little, even from my own perspective or my own experience, when you're denied like coverage for insurance, how few people use the appeals process to say, no, you should have covered that for X, Y, and Z. And I draw a similarity to that a lot of times with the VA, of a lot of veterans out there. They just kind of, okay, I filed a claim, they granted me this percentage, and so I guess that's what I get, and then I just move on. Instead of going back and going, well, is this actually what I should be getting based upon the law? So what I want to do in the last few minutes that we have here is just to give you some examples of what to look at when you receive that decision. I will tell you that I'm very familiar with the large packets of paper that you get that really comes down to, like, I'm looking at a decision that the substantive part of the decision that tells you everything you need is 4 pages long. The packet that we received at a representative included 8 more pages, but we don't get all the additional forms that they're required to send to the veterans in case they want to appeal. So we had 12 pages in this decision, plus some disclosures of if you had fraud or this is how you appeal, that kind of thing. Then there's usually forms. So I understand that veterans often get a packet of 30 pages, 30 plus pages that can be overwhelming. And I can narrow it down to 4 pages that's important, and probably even a page and a half that's important, that which you really need to look at. So if you're looking at a rating decision at all, if you're listening to this on the podcast, you want to slow this down. And for those of you who are listening to this live, just know that all of these shows are recorded, and you can go to our website at veteranslaw.com and listen to previous shows and slow it down a little bit if you want to just take little bite-sized pieces and say, okay, how can I evaluate my decision? So when it comes down to that 12-page, 30-pages that you guys probably got, I'm looking at what we call the narrative of the rating decision. And that is the part where it has the seal at the top that says Department of Veteran Affairs. It will say the veteran's name, their VA file number, and then it starts with an introduction. And the introduction indicates, like in this case, you are a veteran of the Gulf War era, you served in the Marine Corps, and it'll say when they served. You filed a claim on the particular date. This one's December 2nd of 2020. And based on this evidence, we have decided the following. And then it'll say decision. And it'll list, this one has 3 things. Then it will list the evidence that they considered in making that decision. And then it will list each one of those 3 items. And it'll say what they decided and why they decided it. And this is kind of the nuts and bolts of the VA compensation process of if they denied service connection, why did they deny it? If they gave you a percentage, why did they give you that percentage? And what do you have to show for a higher percentage? So I'm just going to give you some examples in our last few minutes here. This one has, number 1, service connection for tinnitus is granted as an evaluation of 10%, and then it gives the effective date. And what's interesting about this one is they filed a original claim, it says in that introduction, received on December 2nd, 2020. The first thing I see is service connection for tinnitus is granted 10% effective February 3rd of 2021. So if he filed a claim for tinnitus on December 2nd, 2020, why are they only granting it as of February 3rd of 2021? That raises an eyebrow to me, so something to look into. So then I go to reasons for the decision for that service connection for tinnitus. And it'll say that evaluation of 10% is assigned, and then it'll indicate that 10% is the highest scheduler evaluation under the law for tinnitus. So you can't, in that case, appeal the percentage because it's the highest thing under the law that they can give you. The question is, why did he receive it on that particular effective date? And then this guy's condition, or in this situation, the evaluation was February 3rd, 2021, because that was the date that he was discharged. So in this guy's case, he filed it ahead of discharge, which you're allowed to do. He filed it in December of 2020. It will only be effective the date of discharge or the day after his date of discharge. So that's interesting. The next thing is his lumbar. He was granted 10% for his lumbar. And it'll list here that 10% includes it's a range of motion consideration. It's a painful with motion consideration. And then it goes into saying a higher evaluation of 20% is not warranted unless the evidence shows, and it includes the range of motion it requires, muscle spasms, forward flexation. So it tells you, and this is actually relatively new, since, they didn't used to do this when I first started doing VA. They didn't specifically explain it right there. So when you're looking at, okay, can I show that, whether my medical evidence shows that, or can I personally show that by giving testimony, making arguments, or providing private medical records, anything like that to show the higher percentage is required. The next one, service connection for a skin condition in the right arm. They gave him service connected, but at a 0%, same effective date. When they give you a service connection with a 0%, what they're saying is they acknowledge the condition exists and it is related to service, but they're giving you a 0% because your symptoms don't rise to the level of a higher evaluation, which for this skin condition is a 10%, that shows certain lesions that affect a certain percentage of the body. So they're going to be very specific in that. So I always go to that particular rating, or narrative is what we call it, narrative, that describes what you got and why you got it, and then look for any discrepancies within what the VA says. So that's how we approach any sort of decision we get from a veteran in evaluating that decision and discussing with the client or the veteran or potential client, do you have these conditions? Like when it comes to a back condition, the questions that we're going to start asking is, when you went to the examination and they did a range of motion measurement on you, was that accurate? Were you having a flare up? Was it a good exam? Was it a bad exam? All of those kind of things to see how we can attack an exam. The other recommendation I will say is always request a copy of your compensation and pen examination report and review it for any inaccuracies whatsoever. That's one way in which you can counteract the 10% that you're given and say it was a bad exam. I could go into that in depth, and we will on a future show, but I just wanted to give a little bit of a highlight on that. We're up against the end of the show here. We'll see you next week. This is Amanda Manier with the Veterans Voice. Have a great week.